This honorable court is now in session.
Good afternoon and welcome to the Court of Appeals. Appreciate each of you and your clients participating in this Zoom video oral argument. It's not the norm, but these days I don't know what the norm is, so we can just throw that out the door, I guess. Uh, Before we get started, I want to go over the ground rules, and then I understand we have an introduction as well. But all of you are experienced practitioners, so you understand that each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, you may reserve up to 5 minutes of rebuttal time, but you need to request from the court after you've introduced yourself and before you begin your argument. The panel for today is Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Uh, we certainly want to recognize Angie Dempsey, the deputy clerk, for making all this work as we've gone through this process today, and also the AOC technology staff. They've done wonders to make it work as well, and we appreciate that. So, Angie, if you'd call the next case, please.
Gloria J. Jones versus Justin Martin et al.
All right, Mr. Owens, I believe you have a announcement or an introduction to make.
Yes, Your Honor. I'm Nick Owens with Owens Law Firm, and it's my pleasure to introduce to the court Ashley Kiss. This is her first time appearing before the Court of Appeals. She graduated from University of Tennessee in 2009. She graduated from Memphis Law School in 2015. She's been with our firm since late 2015, coming up on 5 years of practicing with us. She's done an outstanding job, and she's a fine person. We're very appreciative to have her with us, and she's handled the brief on this issue, and she's going to be handling all the oral argument on behalf of the respondent. Thank you.
Okay. Thank you. Thank you. Ms. Kiss, we certainly glad to have you and welcome you to the Court of Appeals and hope you find it to be an enjoyable experience.
Thank you, Your Honor.
All right. We will now hear from the appellant.
Thank you, Your Honor. My name is Eric Llewellyn, and I represent Gloria Jones and Martino Jones, the appellants in this case. I'd like to reserve 3 minutes for rebuttal.
3 minutes. Yes, sir. You may proceed.
There are two issues before the court. The first is whether or not there is a final order in the trial court such that under Rule 3, the appeal is timely. The second issue is whether or not the trial court erred in dismissing the claims of Martino Jones. Both of these are questions of law and are thus subject to de novo review by this court. I'll start with the threshold issue of whether or not the appeal is timely. Under Rule 3, an order is not appealable if it does not adjudicate all of the claims. There's no dispute that the dismissal of Martino Jones' claims on July 25th, 2019 did not adjudicate all of the claims in this matter because Gloria Jones' individual claims still remained. However, on November 12, 2019, Gloria Jones filed a voluntary non-suit dismissing her claims without prejudice. And at that point, the plaintiff's appellants contend that it became a final order under Rule 3 such that appeal was proper. In support of that position, we have cited to the Green versus Moore case. In that case, the plaintiff had filed claims against the defendant, and the defendant had filed a counterclaim. The plaintiff's claim was dismissed, and shortly thereafter, the defendant voluntarily dismissed the counterclaims without prejudice. The Tennessee Supreme Court found that the time for appeal began at the time of the voluntary dismissal of the counterclaims, even though the defendant had the right to refile those claims. So analogously in this case, we would argue that once Ms. Jones filed her voluntary non-suit, it became a final order such that it was appealable under Rule 3. And it's easy to see the logic of that holding, because otherwise the time for appeal would become nebulous and difficult to know. If it doesn't start running when the voluntary non-suit happens, that is that dismisses the last of the claims, does a party have to wait the full year to see if the party refiles before they appeal? Any other rule would create this moving target where the parties don't know when the time for appeal starts. The defendants have cited the Himmelfarb case for the position that a voluntary dismissal without prejudice is not an adjudication of the party's claims. I would submit that that is true as a general rule. However, in Himmelfarb, the court was not asked to address whether the time for appeal under Rule 3 started at the time of a voluntary dismissal. It was addressing whether or not a voluntary dismissal was a final ruling for the purposes of a malicious prosecution. So the question in that case was different, and the plaintiffs would submit that the Green versus Moore case is more instructive to this particular situation, and that thus appeal is timely. Moving on to the second and more substantive issue in this case, plaintiffs contend that the trial court erred in dismissing Martino Jones' claims. Mr. Jones died prior to the filing of this lawsuit from causes unrelated to the underlying wreck. Ms. Jones filed this action individually and is the surviving mother and next of kin of Martino Jones. The defendants have argued that that filing was a nullity and that Ms. Jones should have opened an estate and had the estate of Martino Jones file this lawsuit. However, defendant's position is contrary to the statutory scheme in Tennessee. Tennessee Code Annotated 20-5-102 provides that Martino Jones' claim survived his death and, quote, shall pass in a like manner as the right of action described in 20-5-106. So we have to ask now, well, how do matters pass under 20-5-106? So when we check that statute, it says that Martino Jones' claim, quote, shall pass to the person's surviving spouse, and in the case there is no surviving spouse, to the person's children or next of kin. Martino Jones was not married. He did not have any children. Gloria Jones, his mother, is his next of kin. Action of a deceased individual shall pass to the person it designated in the proper order indicated by the statute. And in this case, that person was Gloria Jones, and she did exactly as the statute instructed, filed this claim as next of kin of Martino Jones. The plaintiff's actions are also supported, in addition to being supported by the plain language of the statute, they are also supported by case law. The Tennessee Supreme Court in Jordan versus Baptist Three Rivers Hospital held that at the time of death, a survival action is, quote, transferred to the person designated in the statutory scheme to pursue it. Importantly, the court did not say that the survival action is transferred to the estate of the decedent. It said it's transferred to the person designated in the statutory scheme to pursue it. In this case, that is Martino Jones' mother, Gloria Jones. The Jordan opinion was just recently in 2017 quoted and reiterated by the Supreme Court in Beard versus Branson. So as recently as 2017, the Tennessee Supreme Court has again indicated that the survival action is transferred to the person designated under 20-5-106. Finally, the Court of Appeals has had a similar holding in the Miller versus Nyblack case that we cited to. In that case, the court held that a survival action was, quote, properly maintained only by the surviving spouse, close quote, because the spouse was the proper designated person under 20-5-106. Again, the court did not say that the case could only be properly maintained by the decedent's estate. It said it was, quote, properly maintained only by his surviving spouse, close quote. Had Martino Jones had a spouse, the spouse would have been the proper person to bring it, but because he didn't, it passed down the line to his mother. So plaintiffs submit that by filing as Martino Jones' next of kin, Gloria Jones has followed this statutory scheme explicitly and done exactly what she was supposed to do. Defendants have relied primarily on the McCormick case in their desire to have this case dismissed. And the McCormick case is distinguishable because that case was actually filed in the deceased person's name. Importantly, the court even noted that it was not clear who filed the complaint in the name of the decedent. Because there was that procedural deficiency of bringing the complaint actually in a deceased person's name, the court in McCormick found that the complaint was a nullity and that it should be dismissed. But that is not what we have here. Gloria Jones did not file this case in the name Martino Jones. She did not file it Gloria Jones and Martino Jones. That would have been improper. She filed it Gloria Jones individually and as the surviving mother and next of kin of Martino Jones. So it was immediately clear from the complaint who was filing the action. The complaint pled that Martino Jones had no spouse, had no children, and that Gloria Jones was his mother. And we pled the code sections that I've already cited, indicating that Gloria Jones was the proper person under the statutory scheme to bring the action. So McCormick is just not applicable here. It's a very different factual situation. And the trial court respectfully got it wrong when it held that plaintiff's complaint was a nullity because it misapplied the holding in McCormick to a very different factual scenario. And finally, as I've said several times, the plaintiffs maintained that this suit was properly filed. However, if this court disagrees and holds that Ms. Jones should have opened an estate for Martino Jones and filed in the name of the estate, plaintiffs still submit that the appropriate remedy was not dismissal, that the trial court should not have dismissed this action, but should have granted additional time for the proper party to be substituted. Plaintiffs base that argument on Rule 17.01 of the Tennessee Rules of Civil Procedure. That section states that, quote, no action shall be dismissed on the ground that it is not prosecuted in the name of the real party in interest until a reasonable time has been allowed after objection for substitution of real party for the real party at interest. So the operative language there is no action shall be dismissed. It's mandatory language. The courts are not allowed to dismiss cases because they are filed in the name of the wrong party at interest, at least not until after objection and a sufficient time for the substitution of the real party.
That request made to the trial court?
Yes, Your Honor. In our response to the motion to dismiss, we explicitly argued that Rule 17.1 should allow for additional time to substitute in the estate if that is what the court felt was necessary. That was contained in our original response to the court. And the motion to dismiss was filed on June 7th, 2019, and the order of dismissal was July 25th, 2019. So there's a little over a month between the time that the defendants first raised this issue and the dismissal. So I would respectfully submit that it would not have been onerous or to allow it some additional time for us to get an estate set up and substituted in under Rule 17.01, and that in fact is what the court was required to do by the Tennessee Rules of Civil Procedure. So even if this court finds that we should have set up an estate, what we would ask for is that the order of dismissal be reversed and be remanded so that we have time to substitute in the proper party. But the primary thing that we're asking for is just that the order of dismissal be reversed and the matter remanded so that both the claims of Martino Jones and Gloria Jones can proceed to trial on the merits. And I see that I'm running out of time, and it's right on time. So thank you for your attention.
Thank you. We will hear from the appellee now.
Good afternoon, Your Honors. May it please the court. My name is Ashley Kiss, and I represent Justin Martin and Joseph Martin, the appellees in this case. To first address the threshold issue of whether or not this court has jurisdiction. Appellees contend it does not because the order appealed from is not a final order. The trial court's order dismissing the claim of Martino Jones adjudicated less than all of the claims. Therefore, that order was not appealable under Tennessee Rule of Appellate Procedure 3, subsection A, unless Rule 9 of the Tennessee Rules of Appellate Procedure applied as an exception, or Tennessee Rule of Civil Procedure 54.02. Of course, plaintiff's request for permission to appeal under Rule 9 was denied. Therefore, its only remedy at that point was relief under Tennessee Rule of Civil Procedure 54.02, which provides that when more than one claim for relief is present and in action, the trial court may direct the entry of a final judgment as to one or more, but fewer than all of the claims or parties, only upon an express determination that there's no just reason for delay and upon an express direction for the entry of judgment. In absence of that magic language and that determination or direction, any order that adjudicates fewer than all the claims shall not terminate the action as to any of the claims. The order dismissing the claim of Martino Jones did not contain that magic language. And it therefore,
Excuse me, the non-suit by Mrs. Jones, didn't that conclude that particular case?
Your Honor, it concluded that particular case, but as the law in Tennessee states, I believe under Tennessee Rule of Civil Procedure 4101 subsection 2, a voluntary dismissal is not an adjudication on the merits unless the order states that it is an adjudication on the merits, or if the case has been previously dismissed twice.
Well, what's left in the case that was initially filed? Is there anything left in that case?
No, Your Honor, there wasn't.
So this case that Mrs. Jones has now refiled is a separate lawsuit. That's a new case, isn't it?
That is a new case, Your Honor, yes.
Okay, so if there was nothing left in the original case, then how could that not be considered a final judgment?
Well, Your Honor, I can see that I've not been able to find this particular issue that we have before the court in my research. And based on the rule of Civil Procedure 41.02 and the law construing same, it says that a voluntary dismissal is not an adjudication on the merits unless the order so states. And that's how I would distinguish the Green versus Moore case cited by appellants that said, okay, in this instance, we're going to take the time for the Rule 3 appeal, not from the date of the notice of voluntary non-suit, but from the date of entry of the order. And that is where the 30 days starts. Well, in that case, Your Honor, the trial court's order of voluntary non-suit specifically concluded all of the claims and so stated in its order. The order entered by Judge McCraw on plaintiffs' appellant's order of voluntary dismissal said no such thing. And that's the distinction that I would make in this case, Your Honor. Therefore, in the absence of this language, the order is not final, so as to confer a jurisdiction in this court, and the appeal should be dismissed. Getting now to the second issue as to whether or not the dismissal of the claim of Martino Jones was proper. Appellees respectfully state that that dismissal was proper for two reasons. First, Martino Jones was deceased when the complaint was filed on his behalf. Therefore, the suit is a nullity, not amenable to substitution. I concede that the exact situation at issue in the McCormick versus Illinois Central Railroad Company relied on by the trial court is not present in this case. Appellants did not file suit in the name of Martino Jones.
But that's what your motion to dismiss said happened, didn't it? In other words, when in your motion to dismiss, you stated that the suit was filed in Martino's name when he had already died. That was the whole basis of your argument to the trial court. And the trial court, in its order, says the commencement of a suit in the name of a deceased individual amounts to a nullity. So your motion said it was filed in the name of the trial court. Your argument was that it was filed in the name of Martino Jones to the trial court, and the trial court put that same language in its order and relied on the McCormick case. None of that was correct, was it?
Well, Your Honor, it was filed in the name of...
Well, you just said previously that it was filed on his behalf. But in your motion, you didn't say it was filed on his behalf. You said that it was filed in his name. And there's a distinction there, isn't it?
Well, not in this case, Your Honor, because the core issue is that how the suit was filed in both instances, neither one had a legal existence to have the prerequisite to have the capacity to sue. In this case, Gloria Jones, as mother and surviving mother and next of kin of Martino Jones, had no more legal existence than had the suit been filed only in Martino Jones's name. And that's the filing of the complaint in Gloria Jones's name as surviving mother and next of kin is insufficient, Your Honor. And that's what we argue. Without having the legal authority.
How does that work in conjunction with 25-5-102?
Yes, Your Honor. 25-102 states that the cause of action or right of action shall not abate, but shall pass in like manner as the right of action described in 25-106. And it's Appellee's argument and position that the language, the right of action shall pass in like manner, establishes the priority for who succeeds to the right of action, whether it be the surviving spouse first above anyone else or the next of kin. But it is no substitute for opening a probate estate. And that is...
Where does the statute require the opening of a probate estate?
The statute on its face does not, in 25-102, dictate the opening of the estate. But if this statute is read together with the other survival action statutes, as it should, because they are construing the same subject matter and they have a common purpose. When you look to, for example, 20-5103, causes surviving death of a tortfeasor, you see that there, in order to prosecute the claim against a deceased tortfeasor, it must be prosecuted against the personal representative.
Well, do you think the legislature knew what it was doing when it left that language out of 102, or was that you think that they just made a mistake there in not putting that language in there?
You know, it's hard to say until you get into a situation like we have here. But
let me ask it to you this way: the whole purpose, I presume, of having the personal representative in a survivor action is because any judgment would be an asset of the person's estate, of the decedent's estate. So 102, all 102 is saying that, as I'm reading it, and I want to ask you about this, and I think this is what the appellant is arguing. It just says that they have the right to bring the action. The next of kin has the right to bring the action. But ultimately, there may have to be a personal representative appointed in order to receive if there's a judgment, in order to receive the judgment as an asset of the estate. But those are two different things, aren't they?
Well,
I mean, the legislature may have decided to allow the next of kin to bring the suit for any number of reasons in its infinite wisdom, to hurry up and be able to file, maybe to stop the running of the statute of limitations, any number of things. But ultimately, we know under the law, because it's an asset of the estate, that ultimately there'll have to be a personal representative appointed. But the statute doesn't say that it's required on the front end.
That's true, Your Honor. But it's interesting, if you look to TCA 25107, that's dealing with purely wrongful death actions, or even maybe a quasi wrongful death survival action, unlike the pure survival action that we have before this court, that section says the action may be instituted by the personal representative and goes on to name these specific people who can institute the proceedings. But there's no such section under the pure survival statute like the one that are applicable to this case.
But how about when you have a wrongful death case, that's sort of a hybrid cause of action, isn't it? I mean, that was changed, I think, 14, 15 years ago by the Supreme Court. So actually you have the decedent who dies in a wrongful death cause of action has his own cause of action that would then require any judgment to be paid into court, but the beneficiaries would not be required to have it a personal representative because it's their own cause of action. So you've got two different situations there. And the statute doesn't talk about that either, does it? That statute doesn't talk about that.
No, it doesn't, Your Honor. And that's why it's important to look at the Tennessee case law construing these statutes. And when you realize that this is a purely survival action, that distinguishes the Jordan case, the Bearden case, all because if you take the case before Your Honor, everything works out, because in this situation, the only surviving next of kin is the mother. But say in another situation where you've got 5 next of kin, should you have 5 children filing 5 separate lawsuits as, in their own names? And there's real repercussions of that. And that's why having the orderly process of the probate should be had. Thank you.
Thank you.
Thank you. We will hear the rebuttal of the appellant now.
Tennessee Code Annotated 20-5-106 indicates that the cause of action shall pass to the surviving spouse. If there is no surviving spouse, to the person's children or next of kin. It also lists a personal representative as a person who it can pass to. So if we rewrite the statute to say that an estate has to be set up and a personal representative is required to bring the action, then we essentially just cross through the language about it shall pass to the surviving spouse, the person's children, or next of kin. And we have to presume that the legislature meant what it said and said what it meant. And we can't revise the statute. We have to interpret what it says, and it indicates that the surviving spouse, children, or next of kin can bring the lawsuit. And as was mentioned before, the distribution of the assets from the lawsuit is a different question over who gets to bring the lawsuit. And if Mr. Jones had some creditors or people like that who might have access to this money, an estate may need to be set up if there is ever any money to distribute. But there is no requirement written in any of the statute that an estate needed to be established before the lawsuit was filed. On the contrary, the statute says, and the case law has interpreted it to indicate that the cause of action is transferred to the person designated under the statute. Gloria Jones is the appropriate person designated under the statute. That was all pled explicitly in our complaint. To hold that the complaint is a nullity is just a mistake, and the correct thing to happen should be the order of dismissal should be reversed and the case remanded so that both of these cases can be tried on the merits together.
Okay, thank you for your argument. We will try to get you an opinion resolving this issue at the earliest possible date. We again thank you for participating in this Zoom oral argument, and thank your clients as well. Angie, if you would dismiss us for the day, please.
This honorable court is now adjourned.
Thank you.
Thank you. It's